So I am Nate Soderstrom. I'm a senior editor at the Capitol Forum, and I'll be moderating our first panel, which is entitled Antitrust Outlook for Streaming and Studio Consolidation. We have a tremendous group of panelists here today who I will quickly introduce. I will go from closest to me. Aaron Teitelbaum is a partner at Kressin Powers. Aaron is an experienced trial lawyer, antitrust litigator, and former federal prosecutor. Before joining Kressin, he served as a senior litigation counsel at the Antitrust Division of the Department of Justice, where he co-led the department's challenge to JetBlue's acquisition of Spirit Airlines, as well as the Google ad tech monopolization case. Next, we have Danny Sokol, who's the Carolyn Craig Franklin Chair in Law and Professor of Law and Business at the USC Gold School of Law and USC Marshall School of Business. Professor Sokol is among the most cited antitrust law scholars in the United States and is widely recognized for his expertise on digital platforms, mergers and acquisitions, innovation, and global competition policy. Next, we have Michael Hartman, who is DIRECTV's General Counsel and Chief External Affairs Officer, where he's responsible for overseeing all legal, external affairs, and compliance matters. Michael's also served as Senior Vice President, Assistant General Counsel of AT&T Incorporated, and General Counsel, DIRECTV Latin America, where he's responsible for overseeing legal affairs of AT&T's Latin American pay television business. Last, Ethan Litwin is a partner at Shinder, Cantor, Lerner, where he handles complex antitrust litigation and government investigations. Ethan has served as co-lead counsel in significant entertainment matters, including the Writers Guild of America's successful litigation against leading Hollywood talent agencies. Currently represents major corporate and institutional clients across industries, including media and entertainment. So we have a tremendous group of panelists today. To briefly set the stage, when we began setting this panel up, we had, I think, two potential pathways for what consolidation might look like in the near term when it comes to studio and streaming. It was Netflix that had a definitive agreement to acquire Warner Brothers Discovery. Paramount Skydance at the time had made a series of offers that had been rebuffed. Between then and today, Paramount raised its offer again, and Netflix, and I think what was a surprise to many, decided to exit the process. And although that was ostensibly on the economics, the deal had received quite a bit of pushback from elected Republicans, including seemingly the White House. So that is the context, and I think you've seen that with the reaction of many elected Democrats, this perception that the White House, that the Trump administration put its thumb on the scale in favor of the Paramount Skydance bid. And that's where we are. The deal continues to attract scrutiny. We heard from General Bonta earlier today. Clearly quite a bit of state AG interest, as he said, not a done deal. With that, before we actually move to Paramount Skydance, I'm going to ask you, Aaron, briefly on the Netflix deal, the Netflix agreement. When Netflix dropped out of the process, they said they were doing so despite a quote-unquote clear regulatory path to approval. I think there's some market skepticism around whether that was truly the case. Could you talk a bit about, I think, the basis for that claim and your view, and I imagine you've disclosed this, why Netflix would have that view of the situation?
Sure, and thanks a lot for having me. I should disclose, I'm here today in my personal capacity, but my firm did advise Netflix on the contemplated acquisition of Warner Brothers. In terms of the clear regulatory path, I mean, the reason is because that was fundamentally a combination of complementary instead of overlapping assets. I think there was this sense maybe outside of the antitrust bar that because there were two streaming services consolidating, that was a huge antitrust concern, but I think it's important to realize that we're talking about an extremely fragmented and competitive market among streaming services, especially when you consider all the different options that you have for streaming and TV viewing. And it's really the combination of major studio infrastructure that's contemplated with the Paramount acquisition of Warner Brothers that's really the serious antitrust concern here. So when we're talking about why there was a clear path to approval for Netflix, it's really just because at its core, that was going to be a combination of complementary instead of overlapping assets.
Understood. Danny, to bring you in, I know you have a view on this question as well.
Thanks. So I can disclose I'm doing work, and I'm not going to do work for anybody on any of these deals. So my views are entirely my own. Very quickly, so when we hear clear path, I agree that it was clear sort of the kind of arguments to take. I'd say it was a more difficult path than the deal that is announced now. I don't think that's particularly controversial. But let me sort of lay out from an antitrust standpoint sort of what made it clear enough that there was a real possibility. Number one, I'm going to stay away from the complementarities and just look at it from a traditional analysis perspective. First question is market definition, right? So largely, I think we've been seeing a changing market for a while. I've been playing around with the sensor tower data, and there does seem to be some substitutability that we saw that there were not head-to-head competition between the two platforms on the streaming side. But more importantly, and this is interesting, and I haven't done more in depth, but there does seem to be some substitutability with short form platforms like your TikTok or more importantly, your YouTube. And that fundamentally changes things because all of a sudden, if that's the market, there's a very clear path forward, at least from that side. And we see that not just in this case, and again, I'd invite people to use the same kind of data source that looks at app downloads, app usage, et cetera. There's the academic work, none of it yet in peer review, but certainly making its way through revise and resubmit. Probably the best paper along these lines is by Uttara Anatta Christian, who is at Carnegie Mellon but moving to University of Washington this year. Would welcome people to read her work. There's a separate issue, which is the vertical integration issue. Here, it really is the traditional, we know the traditional reasons for and against vertical integration. We've seen cases in recent years. When Macon was head of DOJ, we had the AT&T case. And we had in the most recent administration, Microsoft, Activision, Blizzard, which had elements of this too. And there was, I think, a real path forward. And some of it would be about how you deal with exclusivity of must-carry type stuff. So was there a pathway forward? Yes. Could I have imagined it? Yes. Could I have also imagined, though, some hostility both on traditional antitrust grounds, on these larger political grounds? Also, yes.
Yeah, totally understood. On, and we'll move to Paramount's guidance in a second, just on this question of market definition, I understand the substitutability argument. Folks do watch videos on TikTok, they watch them on YouTube. But I mean, courts have told us how to think about this, right? We think about quantitative factors, we think about qualitative factors. On the qualitative front, distinct prices, industry recognition, public recognition, seems like a pretty strong case. Subscription streaming video is a market. On the quantitative side, if your argument is that TikTok and YouTube and Judge Boasberg, I guess, would tell us Meta would have to be in the market too, we're talking extremely low shares. And then the argument is that Netflix could acquire Prime Video, HBO Max, Paramount Plus, Peacock, Disney Plus, Hulu, pick your paid streamer, and that would all be fine. That hypothetical monopolist could not go up in price, could not go down in quality. That strikes me as a tremendously challenging argument to make. And I will leave it at that unless there is a response.
Well, if I jump in for a minute, early in my career, I worked for MTV Networks in a series of acquisitions where they acquired every channel that showed music videos, finally culminating in the BET acquisition. And of course, our argument was this isn't about monopolization of music videos. Music videos, it's not a market. It's a competition for eyeballs, right? And our biggest competitors were other channels that appeal to the same demographic, like TNT and USA and other channels that showed competing programming. But I think it's different in today's environment. And I think, as we'll get into, we're seeing a massive consolidation in cultural markets. And if I could just comment a little bit about the Netflix deal, and I'll preface this by saying, like everybody else, my views are my own. I don't speak for any organization or any of my clients, and I will try not to comment on politics, although that's hard to do in today's environment. On the Netflix deal, I think it was very clear, and I think Netflix may have said this, that a major reason that they were investing all of this money in Warner Brothers was to acquire their IP. And that's IP to big tentpole franchises, the DC Universe, Game of Thrones, Lord of the Rings, Harry Potter. This is IP with built-in audience. But it also requires tremendous capital investment to produce those type of projects. And even for a company as wealthy and prosperous as Netflix, there's a limit to how much they can invest. And one of the great things about Netflix and what they've brought to our entertainment world are those smaller projects, are those projects that only found a home on Netflix because Netflix was willing to invest in it. And what's going to happen to that capital investment now? Are we going to end up with more Avengers Endgame? Or are we going to end up with a diverse set of voices that's so important we've heard so many of our speakers talk about today?
Aaron, I'll give you the last word, and then we will move on to Paramount's guidance.
Yeah, I guess we have to avoid the temptation to just fight the last war. But I think I'll just say that fortunately, when the Netflix deal was being contemplated, we weren't talking about having Netflix acquire all of the streaming services on this earth. We were having it potentially acquire one of the streaming services where 80% of the subscribers of that service already also subscribe to Netflix. So I think it's dangerous. Each deal has to be considered on its own merits, and we should not be taken in by straw man arguments that we do not have to actually address in the context of a particular deal.
And we will move on. Ethan, to draw you back in, Paramount's guidance actually won the bidding war. No WBD holder vote yet, so who knows, maybe Netflix will surprise us. But we're talking Paramount's guidance. Deal raises quite a few issues, one being how it may affect competition in the market for content acquisition. This could be below-the-line labor, above-the-line labor, spec screenplays, all the way to fully attached projects, the building blocks of movies and television. You, I think, have some views about how we should think about that question and potential lessening of competition there. Could you talk a bit about that?
So a lot of the analysis is going to be driven by data here. There's no question. I'll have some comments about data later on. But fundamentally, we're talking about an oligopoly risk here, that studios are going to be able to compete more effectively on how they bid for projects. They're going to be able to say no more often. They're going to be able to coordinate tacitly more on how they offer terms to those projects they're bidding on. The share of capital, which is what we should all be concerned about, is therefore going to flow more to the owners, to the shareholders, and less to the people who make the movies. The talent that gives rise to this incredibly vibrant industry are the ones that are going to inevitably suffer here. Quality and diversity is what should drive our analysis rather than quantity. We've heard a lot of promises about quantity of films being released, but we haven't really heard about quality and, importantly, diversity. And as I keep saying, cultural markets are different. We heard Commissioner Chopra say, these aren't timber markets. This is the marketplace of ideas. And protecting our intellectual and artistic markets is the highest purpose that antitrust and competition law have. Finally, I'll say that when I think about Paramount, Warner Brothers, it takes me back to the Sony BMG deal in the music industry. Paramount's going to leapfrog Disney Fox, and they're going to leave Universal and Sony well in the distant past. And in that deal, I represented Warner Music in the European investigation of the deal, and we told them, look, you're creating a duopoly that we can't compete with. And if you approve Sony BMG, you make Warner EMI inevitable. Well, shows you what I know. But truly, EMI is now gone. They had to do a deal, Warner Brothers, Warner Media, like soldiers on here. But are we creating a world where Universal Sony is inevitable? And that's something that we should all be really concerned about.
We do hope to arrest trends towards concentration in their incipiency. So I hear you on that. Michael, to draw you in, there is also a vertical component to this transaction. Obviously, it's largely horizontal. You're combining TV studios, movie studios, combining streamers as well. But it'll be a vertically integrated entity in a much larger movie studio, TV studio, and streamer. How do you think about that from your perspective? Do you see potential concerns on the vertical front?
Yeah, so I think, can you hear me? I actually think that in the complexities around this deal, people are going to get very focused on the horizontal issues, 2 studios, 2 streaming services, but people are going to forget the importance of vertical integration and what that means for media. And I would go back to a little bit what Commissioner Chopra said. And sometimes as our industry has evolved and streaming has become relevant, we forget where we come from a little bit in the history, and we forget that we've been moving away from it in a not very thoughtful way, if you think about it from a regulatory perspective. So the way I would frame it is I made a little list. Like since 1948 and the Paramount decision that he mentioned, there has been, there for a long time was a consensus that vertical integration was harmful to competition in media. And that was a very consistent position for many, many decades, reinforced in a lot of different regulatory decisions and judicial decisions. So in 1948, the court said that studios are not allowed to own movie theaters, and they also can't bundle their services in movie theaters. Between 1970 and 1995, similar rules applied a little bit to the FinCEN rules that he mentioned, and also the primetime access rules were intended to curtail the influence of the studios on network programming. In other words, it said they cannot own entities that syndicate rights. This was intended to make sure that they didn't control the distribution platform that was broadcast television. In 1980, with pay TV, a couple of the studios, 4 of them, tried to create a JV called Premiere to create a movie service, and the DOJ said, no, the studios can't get together to control distribution. In 1983, a couple different ones got together to create Showtime and the movie channel. The studios wanted to have ownership in that, and again, that was blocked. That said, content producers are not allowed to control the production, the distribution. In 1994, cable operators got together and they had created a joint venture called Primestar to allocate content, create content, and then license it to other cable operators. That was a subject of litigation. Eventually was approved only when Primestar said that it would not treat other distributors in a non-discriminatory manner. So it had to agree to make content available to everyone. There was an investigation in 2002, movies.com, very similar. Fox and Disney tried to create a VOD JV. That eventually, they in the face of litigation, they didn't go forward. As an attorney in the pay TV business, from the beginning of every time that a distributor and who also owned content tried to merge, the regulators imposed commitments on them of program access and non-discrimination. So it happened when News Corp bought DIRECTV, it happened when Liberty bought DIRECTV, and it happened when Comcast bought NBCU. It was very consistent. Now, with streaming, we've gotten away from that a little bit, and you see Netflix. Netflix converted into an entity that started producing its own content, and with some great benefits to consumers. But as streaming develops, we now have to ask ourselves, where is this market going? And I would posit that vertical integration is still a problem. For example, when Fox and Warner Brothers and Disney got together and tried to create their own service to sell sports content, Fubo challenged that, and they got blocked. And eventually they moved away from that transaction. They got blocked because the judge said, you are creating distribution where you are favoring yourself over other distributors. The judge's opinion is quite clear and quite forceful. So I would suggest that when these issues are looked at in this context, it is still a consideration that vertical integration can pose a problem for the broader industry. And I will just posit, if you want to go back a little bit, this is a little bit off point, but you now have a situation where leading streaming platforms, separately owned, Disney, Fox, and Warner Brothers, bundle their services together to consumers. That's essentially like bundling your movies together and selling them to movie theaters in 1948, I would posit. So I think that in this transaction, although it's just looking at one segment of the market, it's going to be very important not to lose sight of the fact that vertical integration is probably the biggest driver of what's going on in our industry, and that's really the question. Is that in the consumer's interest? Is it in the provider's interest? Who are the other players that could be impacted by that? And what are the kinds of things that could be done to protect against those things that historically were considered to be not pro-competitive or not pro-consumer?
Absolutely. So moving to output markets, if you look at the numbers, I think the merger probably creates what's a pretty weak but very real structural presumption of harm in the market for distribution of movies for theatrical release. I want to pause on that for a second because I think it's important. Aaron, I think certainly from the defense bar, you'll oftentimes hear, look, the structural presumption is borderline irrelevant. Don't worry about it. It's the first inning and nothing else. I think if you look at litigated merger cases and read decisions, you could come away with the view that the structural presumption is borderline dispositive. The truth presumably lies somewhere in between those two poles, but as somebody who has litigated a merger challenge for the government relatively recently, how do you think about that question and perhaps in the context of this transaction or more broadly?
Sure. I mean, certainly if I'm trying to block a merger, I would rather have a structural presumption than not have it. But I think what is often present in cases where there is a structural presumption are some other factors that end up being very persuasive to judges because judges do look carefully at each transaction that comes before them. And I think a strong narrative about harm to real people and competition in a way that you can really make common sense of, either as a judge who's typically a generalist litigator and not an antitrust specialist, is really important. And so I think what we have seen in terms of successful merger challenges in the past is not just that there's a structural presumption present, but that there is also a strong common sense narrative. In JetBlue's spirit, it was affordable, low-cost, unbundled air travel that was going to go away or not be available to people who are extremely cost-conscious. In Penguin Random House, it was a very identifiable harm to these really important books and the effect that it was going to have on authors. And I think here, what courts are potentially going to see if there's a challenge brought is that when merging parties talk about synergies in the billions and billions of dollars in a transaction that is being financed heavily with debt, the word synergy is really just synonymous with cutting people's jobs. And so I think what courts are going to think about are not just things like the structural presumption, which end up coming across as sort of a sterile statistic, but they're also going to think about what impact is the transaction going to have on people's lives as a practical matter, and not necessarily just confined to whatever relevant market is defined in the case, but also just more atmospherically, what is this going to mean for the country and for real people?
They're important questions. Danny, to draw you back in, especially thinking about distribution of films to theaters, it's an unusual market, right, in the sense that it's the exhibitor who sets the price of a ticket, not the studio. So you have competition that's probably largely on quality, and this will be from a consumer-facing perspective as well. There's not a ton of actual price competition to get in the theaters, but again, of course, there's competition for those screens. But when you think about analyzing a merger where, to the extent there's harm, it would presumably be on the quality side, perhaps on the output side, but there's not a obvious through line from output to price the way there would be in a, to call back, forest products type of merger. How do you think about a merger that looks like that, and how do you get to answering the question of, is this going to harm competition, where, thinking about typical models of unilateral effects on price probably aren't going to get you to a good answer?
So a few quick things, and partly let me respond to Aaron in a slightly different way. So what makes for a good case? I spend every year a full semester literally working through what made a good case. And it's a combination of pictures, words, oftentimes written as briefs, and economics, in terms of numbers. But Aaron's right, it's really about telling a story. I shouldn't have to tell a Hollywood crowd, it's about telling a story. But by the way, it's about telling a story. It's just that your audience is one person, and they're grumpy. Welcome to being a parent.
Or a litigator, we should have.
Well, yeah, or a former litigator who's now a judge. So our unilateral effects model really took prominence. Why? Because we could quantify harm very, very easily on the price side. It does less well, as you note, I think correctly, when we're dealing with quality issues, but we've actually seen quite a number of mergers where quality is a big function, or where on at least one side, price is not an issue. I don't think that courts have a problem with that. I think it really comes back to, what do the data show? Right now, we don't know. What do the documents show? Nothing has been made public that looks particularly bad, and I'll contrast that perhaps to what we saw that came out like literally just in the last 24 hours about Ticketmaster Live Nation with some horrifically bad docs. That's not dispositive. We've seen other cases where we have bad docs, but the data goes in the opposite direction. See the Meta case that you were talking about. But I think in the end, it's about telling that story that Aaron's talking about. And right now we speculate the answer is maybe yes, maybe no. It's not a satisfactory answer. But I think there's a lot of prosecutorial discretion for a reason, which is, do we have a compelling story that we think that we can win? And is what we're trying to do full block, or is there some kind of non-structural remedy that we might be thinking about? And I think the more we sort of tease out each of these elements, the more we could sort of handicap the deal.
Thank you for that. So, Ethan, to draw you back in and perhaps move back over to the input side, I think we heard this theme quite a bit already through this conference from acting AAG Mekki, from Director Chopra, from General Banta. This question of input acquisition and how do we think about it? What are the potential harms? Most obviously, right, it's wages, it's for the price paid for a screenplay. But there may be other harms we should be considering as well. And I'm wondering if you could talk a bit about that question.
Sure. So let's just talk about competition. Why do we care about competition? In the United States, we call it antitrust law, but the rest of the world calls it competition law, and that's the much better title. We care about competition because it affects everything that we do. It affects the quality, the choice, the price of the food we eat, where we live, how our health care is provided to us, and now, today, we're talking about our leisure time activities. And if we don't have meaningful choice, and if we don't have meaningful quality distinction in competition, then we're living in a very homogenized society. What is Paramount doing here? Paramount is investing $110 billion to take out a rival when they could be spending it on projects. Is this a world where we think that Hollywood is out of ideas and all the good ideas are now owned by the major studios and they're just fighting to see who controls it? I don't believe that. I don't think anybody who's in the industry in this room believes it. I don't think anybody at Paramount believes it. But they're taking out a major rival. Why? Because when you take out a major rival in a highly concentrated industry, and you go from what was historically a big 6 or even a big 7 at one point to now a big 4 and maybe a big 3, you're taking out bidding competitors for projects. And that results in a much weaker auction and results in all the harms that Nate outlined. But what have we heard from Paramount? We've heard assurances on the output market. We're going to release 30 films a year. We're going to keep 2 lots. We're going to keep separate name brands. Honestly, who cares? That's not what's really important here. What are we losing? We're losing 2 independent greenlighting teams. That's going to lead inevitably to homogenization because you're going to have one view as to what's important, what stories should be told. That leads to a loss of diversity in the broadest sense of that term. You're going to result in the loss of an independent P&L. And that means that you're going to have one decision maker determining risk here. Because all films, even superhero films, and I dump a lot on superhero films, and I'm sorry, but just look at the history of the Fantastic Four. That should have been a moneymaker from the get-go, and they've almost all lost money. But when you're evaluating from a P&L standpoint whether to invest in something, it's better to have 2 independent people evaluating risk than 1. So you're going to have one decision maker determining which products get pursued, which products get priced out, which products get killed at the end of the day. So you're really talking about weakening bidding for the projects that exist on the margins, where, Netflix is a great example of this, who took real risks. They did a limited series and pretty big budget on chess. That's one of the best series I've ever seen, right? Who else does that? Look at the risks that Apple's taking in the market. They're producing wonderful art, and we need to protect that. We don't need fewer development teams. We don't need fewer bets on genres at the margins. We don't want centralized capital allocation, because competition fundamentally in this industry is about content acquisition. It's about project acquisition. It's about empowering artists to do great work. And when we consolidate 2 of the most historic studios in this town, that will inevitably suffer.
So on that front, movie distribution is not the only horizontal overlap here, or content acquisition for that matter. Michael, both companies have a ton of cable networks. Paramount owns Nickelodeon, MTV, Comedy Central, CBS Sports Network, Showtime, and BET, amongst others. WBD owns CNN, TNT, TBS, HGTV, and Discovery Channel. Plus Paramount Skydance, of course, owns the CBS broadcast network. So it's a lot of, I suppose, linear content. Wonder what your perspective is on how that might affect bargaining leverage, how that might affect affiliate fees when negotiating with paid TV distributors. Could we see those go up? Of course, we assume if those fees go up, consumers end up paying more for TV. Do you see risk there? Do you see reasons for concern?
I mean, the market for cable channels is already highly concentrated. You have maybe 4 major providers right now already. So now you would have 3 major providers. So where there's that kind of concentration, yeah, I think it will. There's a very good chance that's going to drive prices up. When you drive prices up, it means consumers have to pay more. But I would just add, it's going to, when you create more leverage, you don't just drive prices up, but you can insist on terms that create different disparities, because a lot of that content that's in those channels is now in the D2C services as well. And so it can create a lot of disparities between the terms that are offered to the third-party distributor to license that content and the terms and the manner in which it's distributed into DTC services. I'm referring specifically to bundling. A lot of cost gets driven onto customers because of bundling requirements when we license channels. And so when we're required to distribute big fat bundles, but our content providers are providing that content at lower prices in smaller packages, that creates a competitive disparity too. So there are actual costs, the money you have to do on the channel, but there are also costs in terms of the terms of the licensing that get exacerbated when there's increased leverage.
To turn back to the input side of things, and Danny, I'll draw you back in here. I know there's this question, who is the market? Could there be a market of targeted sellers? I know the former acting AAG spoke quite a bit about Penguin, Random House, Simon & Schuster earlier. There you had a targeted seller market of, I forget what it was exactly phrased as, but, you know, blockbuster books, for example. And again, this was a merger of two book publishing firms. I'm wondering to what extent you see at least potential parallels between Paramount, Warner Brothers, and the Penguin Random House merger.
Sure. I'm going to reframe that question. Do you have a spidey tingle? And the answer is, I do. So, first of all, sorry, specific to your question.
Appreciate that.
There we go, sorry. So let me take one step back and say, on the vertical side, I'm overall less concerned. Where we have the most recent empirical work actually looks at vertical integration of Chinese theaters. This is Rickard Gill and co-authors last year in the Journal of Law and Economics, actually showed that vertically integrated theaters in China did better. Nor is it the broader economics literature on vertical integration. The most recent paper surveying that in the specific antitrust merger context, Jeff Prince saying it's been pro-competitive. I draw generally these things to your specific question and say, here I do have a spidey tingle. And so let's remember what that deal was. You heard Doha Meki talk about it, so I'm not going to go into detail, but say, like, do we have something similar here? And Ethan, I want to draw you back in. Actually, yes, superhero movies. So let me explain. Most theaters, they're not making money on the kind of beautiful prestige movies that you're thinking about, or even prestige television. We call it prestige, which is to say, I have a child who is an English major in a private school, kind of thing. Where do you make the money? And where does it look like a certain type of author who can command a high upfront amount? It's the superhero movies or the equivalent. And there, I think that these concerns may be significant. It's something that I think the merging parties would have to answer, but I think that's a real concern.
That's perfect. Slight addendum, in addition to making money on superhero movies, theaters certainly make money on the concessions, as we can all appreciate. So that all makes sense. Want to talk a bit about potential output effects from Paramount, Skydance, Warner Brothers. So the CEO of Paramount Skydance, David Ellison, is committed to 30 wide theatrical releases annually post-merger. And obviously, we think there's probably a link between output of those films and spending on acquisition. Presumably there will be. So he's promising to maintain, if not increase, the two studios' output. On the other hand, we have a merger from the relatively recent past, which was Disney's acquisition of Fox that combined two major film studios. People phrased it as a 6-to-5, at least of legacy movie studios. I think that's probably right. In the 3 years pre-merger, they combined to release 24 films annually for wide release. In the 3 most recent years, they combined to release 14. Market-wide, if you include all the big studios, ex-Disney, there's been a 7% drop in theatrical release volume. So it seems like the pro forma firm really substantially reduced output. It seems like remaining rivals did not make that up. And I'm wondering what that should mean, if anything, for thinking about this merger. Aaron, I'll draw you back in here. We have a prior merger. Some would call it a natural experiment. Others would not. But it's certainly a prior merger. A bunch has happened between 2019 when Disney closed Fox and today, COVID, streaming, et cetera. So there are non-merger explanations. That said, if you just look at that merger, you would say, look, we should have serious concerns about reduced theatrical output post-merger.
I think when you're trying to figure out what is going to happen from a merger, two extremely important data points are, as you alluded to, Nate, what happened in the past with similar mergers, and also what are the real-world economic incentives going to be of the combined entity. Not so much what do they say in the press in order to get, high approval ratings essentially for the contemplated transaction, but what are their incentives actually going to be? So starting with history, maybe with the exception of The Empire Strikes Back and The Wrath of Khan, generally the second movie in the series is worse. And I think we can expect that it's definitely not going to be better with this transaction, and it's probably going to be worse. And we left out another transaction in addition to Disney Fox, which is Skydance Paramount. So we're actually talking about the third movie in a series. So with the exception, perhaps, of Indiana Jones and the Last Crusade, the third movie in a series is even worse than that. And so I think what we should be really concerned about is what we saw with Skydance Paramount was the cuts of jobs were very significant. And with Disney Fox, the reduction in output was very significant. So I think history speaks for itself when we think about what we can expect. Now, in terms of the economic incentives, also, I think the question to ask is, and there's actually a principle, an evidentiary principle in merger cases, that you give a lot less weight to the statements of companies after the merger is already under regulatory scrutiny, because there's a recognition that people say what they need to say in order to get the deal through. And so I think that principle should also apply just in the public domain more generally about what people say. And second of all, I think the question that people should be asking is, do we really think that this is what the incentive is going to be to increase output to a level that I think has not really realistically been seen from a studio, at least since the 90s, if not before? Nobody is running a charity here when they are combining businesses. They're thinking about how to be as profitable as they can. And in this particular instance, they're going to have a lot of debt to service, and they're going to have to come up with ways to try to realize the synergies that they promised from the deal. And I don't think, this is my sort of armchair prediction, having not seen the documents and not seen the economic data, that a dramatic increase in output is not the most plausible outcome here. I think what we're more likely to see is maybe like Back to the Future 3, which I enjoyed, but it was definitely it was not Back to the Future 1.
If I can just,
On that, we can all
if I could just,
Michael, please.
yeah, if I can just chime in there, in addition to looking at prior cases as evidence about what's going to happen, you have to look at what's going on right now in the industry, right? The big streaming services are trying to get more profitable by cutting back on their content spend. So there's a conflict between your content spend and your profitability. And when you're under economic pressure, especially when you have debt and the service payments come up, that can pretty much tell you what the incentives are going to be, I think.
Yeah, if I could just jump in there, I think Michael's absolutely right. Words are wind, money talks. And if you look at the balance sheet of this proposed entity, you're going to see a debt-beleaguered studio that's suffering from a 3.3x leverage, going all the way up to 4.3 at best, using synergized EBITDA. And whether or not you believe those numbers or not, that's a horrible best-case scenario. And you're looking at $6 billion in cuts coming. I mean, it is horrific to think about the debt that is going to be imposed on this company. And when you're looking at mergers, and I defended my share of them, It's something that the agencies almost never look at, which is debt. Debt is a driver, and you need to understand how a company is going to deleverage and what that's going to mean for competition. And I think here, in an industry where movie theaters are not doing well, investing into that falling revenue pie makes no sense whatsoever.
Two very quick reactions. The first is, I totally agree as to where the industry's heading and the junk status. The only sort of additional wrinkle is just yesterday, the head of Bank of America made very clear it would take many, many years to get to profitability. That's hampered in part by the fact of the claim of, actually, we're not going to do the kind of sell-offs that, frankly, you would need to do to service the debt. But that all said, antitrust isn't in existence to basically bail out companies from making stupid decisions for mergers. That's not what the antitrust law does. The antitrust law just looks at the competitive effects. Where it does make a difference, to Ethan's point, is to say, we just don't think that certain things are credible because we don't have the money to do it. But whether it's corporate law or antitrust law, overall judges are very reluctant to step in the shoes of boards of directors and say, this is the deal you should have done.
Yeah, and that makes sense. I mean, I think another area judges oftentimes have difficulty with, and this is to Aaron's point on the fact that a federal judge is typically a generalist federal judge. Is not an expert in antitrust. They're not an expert in finance. And you look at this pro forma company, right? So we're projecting $6 billion in annual cost synergies. Others have suggested that number could be quite a bit higher. You have $79 billion in debt post-merger that is now junk rated. And you have this executive promise to actually increase theatrical output into the teeth of what is seemingly a stagnant or declining market. I think two questions, and I will just leave this to the group. A, can compelling executive testimony, incredible executive testimony, and I'm thinking in particular about the T-Mobile Sprint case, right? Because if you read that decision, and I don't suggest you read that decision, but if you do.
I teach that decision. It's a great decision.
Can we cut this? Oh, no, okay. We'll do last 10 minutes. But it seems like Judge Marrero's fundamental conclusion was, look, these guys were just tremendously credible. And look, when Charlie Ergen told me that he was going to build a facilities-based wireless network, he seemed credible. John Leisure seemed very credible. I have no reason to think David Ellison wouldn't come across as credible on the stand. I mean, say what you will, he clearly loves movies, he loves storytelling, and I guess the question is, can that kind of executive testimony perhaps be more compelling than the underlying financial incentives related to that? Again, a generalist federal judge, you're coming with two experts, and they're talking net debt and EBITDA and cost synergies. You could see a scenario where he or she might not be the best person to grapple with those dueling narratives. With that lead up, I don't know that there was an actual question in there, so I will, if anybody would like to respond to what I just said, please feel free, in any order.
I think about the T-Mobile Sprint decision as the sort of, it's like the emoji that you put on your phone where it's just like, who's to say? I'm also not a huge fan of it myself. But I think, the question is like that testimony that you might get at a trial, it's going to be as credible as if it's plausible based on the economic analysis and based on the documents that are in the case. And so I think, one of the things that effective antitrust litigators, of which there are many first-rate antitrust litigators at the state attorneys general, including in California, will know that they need to do. They know exactly what someone like David Ellison is going to say on the stand because he's now been saying it for a while. It's not going to come as a surprise. So they have plenty of time to prepare to show why maybe the economic incentives don't line up with the promises that are going to be made. And so I think that's, I think courts have enough common sense, especially if they're presented with some historical examples of times when credible seeming promises were made on the stand that just simply did not come to pass, and pretty quickly did not come to pass, too. It's not like, oh, in the fullness of time, after 7 years, we realized circumstances had changed. It's more like within a few months, we're doing the exact opposite of what we said we were going to do under oath. And I think that there's a recognition on the part of most of the federal bench that they need to have a healthy dose of skepticism when a CEO testifies, just as they should with any witness.
And I would just make the obvious point that it's very hard to evaluate somebody's credibility as a witness based on how they speak in public, because their credibility will be determined largely by the record of the documents in the file and the people working around them and the consistency of their statements and the analysis that they're going to present on the stand.
It's a very good point.
Although I'll say a dynamic CEO makes for an incredible witness. You just cannot put enough emphasis on what that means in the course of a trial. Having that type of dynamic person there matters. But you notice, again, that all his promises have been on the output side, not the input side. And if this case is going to be tried correctly, it's got to focus on the input side because that's where it's weakest.
On T-Mobile, I'll say the data was actually really good as to real operational efficiencies. We even get a footnote of, by the way, it's not just an efficiencies case, but if it were an efficiencies case, oh my God, would this be the best case ever? I'm not sure that we have any indication right now that that would happen here. Everything, what everybody else said, I think is absolutely right. I will also just note that I'm in an industry where presidents have been on this in hearings and they get fired. So I would say the same thing. None of them seem very dynamic. And to Ethan's point, I think that's right. Like, you have somebody with, if I may say so, Seinfeld-like Kavorka, it helps.
I don't have a better way to wrap up the panel than that, so we're going to wrap up the panel. Thank you, everybody. Thank you to our panelists.